Hi everyone, Jay here from Flow Migration Law. Thanks for joining me. Let's talk about something that causes a lot of anxiety for visa applicants: past mistakes. Your relationship might be very genuine. You've built a life here with your Australian partner, but there is something in your past that you are worried about. A criminal record. Can a mistake you made years ago stop you from getting an Australian partner visa today? The short answer is, it can be a major hurdle. Today I'm going to share a real case study about a client who faced this exact problem and show you how we approach this strict character test to get his partner visa granted. Okay, so let me tell you about our client. He was from Germany and had been in Australia for nearly 2 years on a working holiday visa. During that time, he met his Australian partner and they fell in love. They built a life together, lived under the same roof, and even registered their relationship to formalize their commitment. They were ready to apply for the onshore subclass A20 partner visa. The relationship evidence was solid, but there was a very serious complication. Years earlier, during a tough time in his late teens, our client made a mistake that led to a criminal conviction. The sentence was for 2 years, but it was fully suspended, meaning he never actually spent time in jail. He had well and truly moved on with his life, but that old record was now putting his entire future in Australia at risk. This brings us to the main legal challenge, Section 501 of the Migration Act, also known as the character test. The purpose of this test is to ensure that people coming to Australia are of good character. An applicant will most likely fail the character test if they have what's called a substantial criminal record. Now, here is the critical point that many people miss. A person is considered to have a substantial criminal record if they've been sentenced to 12 months or more of imprisonment. And under migration law policy, a suspended sentence could also count. So even though our client never went to jail, his 2-year suspended sentence may mean substantial criminal record. This is a red flag for the department. It makes his application would get a much higher level of scrutiny. It was possible for his case to face a special character assessment unit in the department called the VACU, the Visa Applicant Character Consideration Unit. We knew we couldn't just lodge the application and cross our fingers. We had to tackle this character issue head on from the very beginning. Our strategy wasn't just to prove the relationship, but to build a comprehensive case demonstrating the person he is today. We worked very closely with the client and his Australian partner and focused on 4 key areas. First, rehabilitation. We documented everything about his life since the offense. We showed the positive changes he's made, like finishing a university degree and building a successful career. This painted a picture of someone who had learned from their past. Second, the genuine relationship. We provided powerful evidence of their committed relationship and their shared life and future plans in Australia. Third, the hardship to the Australian sponsor. We detailed the significant emotional and financial hardship his Australian partner would face if he was refused a visa. She had a whole life and career here, and a separation would shatter the world they had built together in Australia. And finally, full disclosure and remorse. The client wrote a detailed personal statement. He took full responsibility for his past actions, expressed genuine remorse, and explained the person he has become since that difficult time. We didn't hide from it, we addressed it. By putting all of this together, we presented a full picture to the department. We gave the decision maker the information they needed to see his rehabilitation, the genuine nature of his relationship, and the hardship a refusal would cause. It allowed them to weigh all the factors and exercise their discretion favorably. I'm very happy to say that after careful consideration, the department granted our client's partner visa. The couple could finally move forward with their lives together in Australia, without the cloud of uncertainty hanging over them. So what are the lessons here? 1. A substantial criminal record, even a suspended sentence, is a very serious matter in Australian migration law. Don't underestimate it. 2. You must provide full and frank disclosure. Trying to hide an old offense is one of the fastest ways to get a refusal. It is always better to address it up front. And 3. When character is an issue, a standard application is usually not enough. You need to build a persuasive case that tells your whole story. Navigating the character test is complex. I have dedicated over 8 years to handling the complexities of Australian migration law, including many sensitive cases involving character concerns. Presenting your situation in the most thorough and compelling way is vital. If you have a past record or any character concerns and need legal representation, please reach out to me directly by emailing me at js@flowmigrationlaw.com.au. We can book a consultation to discuss your specific situation. Thank you for watching. I hope this story has been helpful. If you found it valuable, please give it a thumbs up and subscribe for more insights into Australian migration. I'll see you next time.